it'll be a good time to start so that we don't keep anybody waiting. Thank you all for joining us today for this important webinar titled A Simple Guide to Unlocking Inherited Wealth Through the Probate Process. We're excited to have you join us for this session. Whether you're tuning in from home or the office, we appreciate you taking the time to be with us. We will be diving into unlocking inherited wealth through the probate process now, and I am confident you'll walk away with some valuable insights and actionable items. We're also aware that navigating the probate process can be confusing and quite overwhelming, especially when trying to access inherited wealth. But today, we've brought together experts who will break down this process, help us debunk common myths, and share practical tips to help you handle the process with ease. But before we get started, just a few housekeeping items I would like to bring to our attention. Come on, if you have any questions during the presentation, please feel free to use the chat feature. We would address as many as we can during the Q&A session at the end of the presentation. This session is also being recorded, and the recording will be shared with you afterwards using the registered email address that you provided. And if for any reason you encounter any technical issues, let us know in the chat and we will do our best to assist you. Without further ado, let us get started. It's my pleasure to introduce our speakers for today. Michael Abiodun, who will guide us through the session as a guest speaker, and Joseph Jibunoh as our co-guest speaker. And we are thrilled to have them with us. I am honored to introduce our distinguished speakers. Mr. Michael Abiodun Thomas, our distinguished guest speaker, is the Managing Director, CEO of United Capital Trustees, where he drives strategy and operations across various trust services. With a track record managing over $8 trillion in major trust transactions, his expertise spans corporate, public, escrow, and estate planning. He previously held roles at the ARM Trustees Limited and the Radix Trustees Limited, and is a barrister and solicitor of the Supreme Court of Nigeria. Michael is also an alumnus of the Lagos Business School and the Cumbria University, and holds a postgraduate diploma in Law of Trust from Queen Mary University. He is also the General Secretary of the Association of Corporate and Individual Investment Advisors and a Fellow of the Association of Investment Advisors and Portfolio Managers, just to mention a few. Mr. Joseph Jibunoh, also our guest speaker, is our Company Secretary at Africa Prudential and our legal advisor. He is a seasoned corporate counsel with over 20 years, that's 2 decades of experience, spanning legal practice, banking, insurance, real estate, and capital markets. He's an expert in corporate governance. He's an alumnus as well of the Lagos Business School's Senior Management Program and has completed the executive training in the Blue Ocean Strategy. Joseph is also a member of the key professional bodies like the Chartered Institute of Secretaries and Chartered Institute of Arbitrators, amongst others, and again, just to mention a few. We are also joined by our expert panelists, specialists in operations particularly, who will walk us through how Africa Prudential can assist you in getting started with this journey and this process that we're delving into today. First, we have Temitope Awereoba. She is the head of operations in Africa Prudential PLC. Temitope holds an MBA in business administration. She has 18 years of experience in share registrar administration and has affiliation with the prestigious professional bodies, including Associates of Institute of the Capital Market Registrar, and the Chartered Nigerian Institute of Management. She is seasoned as well as a professional with extensive experience in driving operational experience within capital markets. From her roles as the head of operation, Temitope has consistently delivered outstanding results and cultivated valuable relationships throughout her distinguished career. And then we have Muritala Afolabi, the last but never the least, our regional operations head in Port Harcourt, who has over 17 years experience in the capital market operations, along with building relationship management across the capital market. Is also an associate member of the Institute of Capital Market Registrars and the fellow of the Chartered Institute of Loan and Risk Management of the Nigeria. Now, having introduced our fantastic and distinguished guest speakers and our speakers, we would ask that let's dive into today's session, starting with an overview of the probate from our first speaker, Mr. Joseph Jibunoh. Joseph, thank you once again for joining us today. As I hand over to you, would like you to give us a brief definition and purpose of probate, which will be an introduction to what probate is, in the first place, which will now set the baseline and background for what the topic we're discussing with today will roll. Thank you very much, Joseph. It's take the floor.
Thank you so much, BJC. The Holy Scripture tells us that there's a time to be born, and after that, there's also a time to die. But the question is, after death, what happens to the property or assets that we leave behind? So that brings us to the meaning of and definition of probate. So probate simply deals with the procedure of administration of the estate or assets of a deceased person after his or her death. It is a legal process that leads to authentication of the last will and testament, the appointment of an executor, and distribution of assets to the intended beneficiaries, either in line with the will of the testator or in accordance with the law of the state where the person was domiciled as at the time of his death, his or her death. So when we are talking about estate, it could be money in banks, it could be shares of quoted companies to registrars, it could be vehicles, it could be real property, it could be personal articles, or even intellectual property, such as even your social media accounts. What will happen to your Facebook accounts, your LinkedIn, and all of that after you have gone. And this can also refer to pension funds, money in your pension fund accounts. So when we talk about probate, it refers to the general procedure for grant of probate or letters of administration, either in contentious or non-contentious issues. So there are three types of probate, basically. The first type of probate is the first one where a testator, that is the person dies leaving a will. And in that will, he has appointed some known persons as executors who will execute the will. And in that case, it simply means that when the person passes on, the will be propanded. That is, the will be taken to court, read, and the executors will be authenticated and granted the powers to begin to implement execute the will. The second type of probate is grant of probate with will, but with unwilling executors. In this case, the testator has prepared a will, filed it. Upon his death, unfortunately, the executors are not willing to take up the responsibility. It could also be a case where the executors are simply not available. They cannot be located. Or it could be a case where the executor has died even before the person that made the will. So when that happens, the interested persons or next of case can apply to court for substitution of that executor that is unable to take up that responsibility. The third type of probate is the one where the testator did not leave any will at all. And this is the most common occurrence out of the three types, whereby people pass on believing that what will be, Sarah, and all of that. So what will happen is that when a person dies without will, the beneficiaries or interested persons related to the person will apply to court for appointment of administrators who will manage the estate of the deceased. So the key difference between probate, where a person has left a will, is that you have people who will handle the estate of the deceased persons are called executors, and in the case of letters of administration, it is the administrators that are appointed by court that will manage the assets of the deceased. So why is probate so important? It enables the testator to give directions on how his affairs should be handled after his death. It also will enable him to appoint trusted persons to administer the estates and dispose of it in line with his wishes. When you also have a probate, will also enable the testator to give specific instructions about guardianship of his children, even funeral arrangements, payment of his debts, his or her debts after death. When we are talking about the importance of probate, it also extends to, it's also one of the requirements for banks. If for money that are in banks, once a person passes, the bank will not release it to anybody, except those who have probate or those who have letters of administration. The registrars of companies where the deceased have shares to will not deal with anybody coming to claim the shares unless they have been granted probate or letters of administration. So it prevents, in other words, it also reduces the incidence of unpaid dividends. One of the reasons why we have a lot of unpaid dividend is that the successors entitled, that the people who are the beneficiaries of the estate of deceased persons, are unable to produce probate documents or letters of administration to be recognized as the rightful claimants to these shares or dividends, as the case may be. It also will enable, ensure that certain, negative customary practices are not implemented in case of a deceased person. So we can go on to, there are so many benefits of having a probate. It also prevents conflict between people claiming to be legal executors. It might interest you to know that there's an office known as the Administrator General of Lagos State. It also exists parallel in other states. Administrator Generals are appointed by law to take over the estates of deceased persons, especially in contentious cases where in a family, the beneficiaries of an estate are fighting over it. One of them can, apply to the Administrator General to take it over the asset of the estate, or even the Administrator General himself can intervene to take over these estates. So you can see the implications of not having a probate, not having a plan in place. So it helps to ensure that disputes are minimized and there's a seamless transfer of assets to rightful persons. So that is the summary of it. I will just add that having a probate enables the testator to have a structured and legal platform for distribution of his estates, his or her estate upon pass. Thank you, BJC.
Thank you very much, Joseph Jibunoh. You've really created a background for today's webinar. I liked, at least I've learned that it's a journey. There's a time to be born, obviously, and there's a time to die. But from all you have said, it's obvious that there's need to plan during the course of our journey, such that the people we have left behind are not lost in the midst of all we have acquired and all our accomplishments. I've also noted that you have detailed processes like appointment of administrators, execution of wills where people die interstate, and granting powers to the executors of the will. All of I've learned now, and I hope our audience are also enjoying this insightful exposure that we are bringing to you. And then we now come to Mr. Michael, who will take us through the role of trustees in the probate process. We are speaking both from the registrar point, and we're also speaking from the trustee side. And so it's very important we understand how all these roles play and what exactly we're supposed to do as people sitting on wealth and we may not know. So there again, Mr. Michael Thomas Abiodun, I'll ask that you please take us through the role of trustees in the probate process. The floor is yours now. Thank you, Mr. Michael.
All right, Bukola, thank you so much. And I want to thank you, Joseph, for laying a bit of the foundation to it. And again, a lot of people have asked that, why is this process seemingly complicated? And it is not. And I'll tell you one of the first things to do, and I say these are everyday occurrences that people face, particularly in the two scenarios where someone passes on leaving behind a will or dies intestate, that is, died without any form of estate plan and did not create a will, as Joseph rightly pointed to. In that instance, I think the first thing to do is to be humane. A family is grieving, they've lost a testator that left a will behind, and the trustee has been named as the executor, either as a sole executor or as joint executor to the will. I think the appropriate thing to do is to notify the family that you have the intention of filing in court the will, at the probate division of a high court, and perhaps to ask the family again if they would allow, if they want the filing to be done immediately, or they would want a grieving moment. Some family indicates that they will want the burial of the deceased to be over before any filing at probate is being done. The next step, once that is confirmed from the family, is to, send and file that probate proper, to file the will at a probate division of a court, and that is to approach the registrar of the probate division of the jurisdiction where the deceased has passed on. And I'll give you an instance. Perhaps you live on Lagos mainland, the Ikeja High Court, or you live on the island, then the Lagos High Court will suffice for it, which is a very direct thing. Note that at the point of filing for this probate, which is called the testamentary letters, typically you would also want to file, obtain a death certificate from the National Population Commission to actually certify that the deceased has passed on, and to notify the probate court of a likely date for the reading and the marking of the will. The court will have to call the family member and share a list of those people who should be around at the court hearing, and a day is being chosen, and that day is communicated to the family members. When the will is being read at the probate division of that court, the will liaise with the probate registry for a grant of probate to be given. And this enables the trustees to be able to begin to take over the asset and begin to generate an inventory of assets. So whether they are stocks at the CSCS, bank accounts, you want to collate all of this, whether they are tenancies that are dues, real estate, different point in time, the trustees take over this and begin to run through this entire process. The reason why this inventory is very important is for two very important reasons. Number one is because that inventory list will be filed at the probate division, so that the courts, so that the probate division can compute the tax, the estate tax, and the trustees facilitate that estate tax payment. And number two is to also be able to be sure that the entire asset that goes to the beneficiaries for distribution is adequately processed and kept in place. Now, all of these apply to those who left a will behind. And again, handling the estate, dealing with disputes, and eventually closing that estate are all processes that the trustees embark on in the course of what they are doing. Note that they are selling testamentary trust. That means trusts that are created out of a will. When those testamentary wills are being read and a trust comes alive from them, the trustees is required to continue to manage that trust on behalf of the beneficiary. But this applies only to those testators who left a will behind. In the event a person dies intestate without a will, the process simply means, after notifying the family, the trustees will, upon their appointment, will approach the court to obtain a letter of administrator. administration. You would note that if there is a will and then you have executor, but if there are no wills, the court will have to appoint an administrator, and this is done by applying for a letter of administration. An inventory of the asset is also taken. The death certificate from the National Population Commission is also being shared. All of this is filed within the jurisdiction of the court, and when that letter of administration is being granted, then the process of the payment of the estate tax is done after inventories are also being filed. We want to also state this, that the relevant estate administrative law of each state will apply, and those processes may slightly vary from state to state, but generally these are the laid down steps by which we go and then run this entire process through. I would also let you know that the letter of administration process takes a longer time, because the clear indication of where the assets should be, how many assets are involved, where are they distributed, is a whole lot more difficult task to clarify. Some people have also asked, who can be an executor? A family member can be an executor, a trusted friend can be an executor, and all of this has its own disadvantage, and a corporate trust can also be an executor. The benefit is the ability to have professional expertise, experience, and as well as the impartiality that comes in being able to administer this process. I hope this is helpful. Thank you.
Thank you very much, Mr. Michael. So it's obvious we're from an individual perspective how to process a probate, and also from the trustee's perspective. He has also gone a notch forward to explain that most times it's easier to have it tidy, and that's why there's a role for the trustees. However, we might choose to do it whichever way we want, but the most important thing is you're being educated and empowered on how to go about probate and wills generally. I would like, and I see your questions are already coming in. Thank you very much. We're going to answer your questions shortly, but let's quickly absorb as much as we can during this process. I will now go back to Joseph, our guest speaker as well, who will be taking us through the legal process of validating a will. Joseph, take us through this process.
Right.
Thank you.
Thank you very much. Thank you very much, BJC. The earlier speaker, my colleague Thomas, has actually highlighted some of the process, especially as it relates to where a trustee is involved. But basically, the process of obtaining probate in Nigeria varies from state to state. Each state has an administration of estate law. In addition to that, we also have the various High Court civil procedure rules that guides the step-by-step, provides a guideline about how an applicant or their solicitor can apply for grant of probate. So in Lagos State, for example, we have the administration of estate law and the High Court civil procedure rules. In terms of time, when a disease passes, there must be a time lag to observe before an application is filed for probate. In Abuja, it's about 7 days. In Lagos, it takes, you must observe a period not less than 14 days before one can apply for probate. Then again, who can apply for probate? As explained by my colleague Thomas earlier, any interested person, could be a family member or even a corporate trustee appointed, can apply for probate. But we must stress here that grant of probate is applicable to those who are married under statutory law. That is, in popular parlance, those who underwent court marriage are the people who can apply for probate. Anybody who did not go through that process is deemed to have passed through customary or Islamic court. In that case, the options open to those people is to apply, in the case of customary, those who are married under customary laws and traditions, apply to the customary courts of the locality where the deceased lived before his death. And then if in the case of a Muslim, you can apply for the applicable Sharia courts, or in the north especially, you have the area courts that handle these matters, Islamic courts that handle these matters. So as already pointed out by my colleague, the first stage for a will is first of all to go on discovery for the will. Following the burial of the testator, a diligent search is conducted at the probate registry to see if the will is lodged. It is very helpful if the receipt of lodgement of the will is available. If it's available, it becomes an evidence for the family members to approach the probate registry to report that they have a will lodged there to be propounded. And so when that is done, if a will is found, the family solicitor representing the beneficiaries will proceed to apply for the probate to the registry for an official reading of the will. So next will be the opening of the will. On the designated date, in the presence of all invited family members, the delegated officer from the probate registry opens a sealed envelope containing the deceased will. The envelope is typically sealed upon lodgement with a candle wax, and that's an evidence that would be an evidence that it has not been tampered with. So when that is done, then the reading of the will be the next process. The probate registrar, upon presentation of an official copy of the death certificate, invites all the family members to attend the opening and reading of the will. So when everybody is present, the will is read to everybody's hearing. And then if there is no objection to the will of the deceased, the testator, the next stage is the executors, for the executors who are appointed in the will, to apply to probate for probate. This could be done directly, or it could also be done through their solicitors. So once the will has been read, the appointed executors can now proceed with the forms, prepare the forms, and attach and obtain necessary documents. So when all the documents are attached, next is submission of the application for probate. The specific requirement varies from state to state. But some of the documents, of course, will include evidence of the death certificate, the NPC, National Population Commission certificate to show, of course, that the person has died, ID card document of the deceased, ID card document of the applicants, and an undertaking to pay applicable fees that will be assessed. So once the application is submitted to the probate registry, the registry will issue what they call a bank certificate. This is a document that captures the details of the assets, liquid assets of the deceased person, such as bank accounts and shares. That is the purpose of the bank certificate. Then the next stage after issuance of the bank certificate is the information gathering. That is, the executors take the bank certificate to the relevant banks and registrars where the deceased held accounts or shares pertaining to these assets, such as the balances and the share portfolios, are recorded on the bank certificate and then endorsed by the bank or the registrars with their stamp of authority to show that, yeah, these are the true balances. The purpose of this is to enable the probate registry, to assess the percentage of tax, debt duty payable for the grant of probate. Where the deceased person also has real property, the valuation unit of the probate registry will conduct an inspection to determine the value of the estates. Subsequently, an assessment of the payment of the estate fee is issued. The estate fee is typically calculated as a percentage of the property value. The amount indicated on the assessment sheet or probate sheet constitutes the probate fee payable. Now, the next is payment of the fees. Once the assessment has been issued, the applicant will collect it and proceed to designated banks to make the payment. So a common problem in processing of probate is that most times applicants don't have money. Yes, the deceased person have money in the bank, but the applicants themselves, the beneficiaries, don't have money to pay. So there's a common practice which is allowed, is that where the deceased person has money in banks and it's already disclosed in the bank certificate, the applicant can apply to the probate registry to issue an order to the bank where the deceased person has money for the debt, the amount of debt duty payable on that estate to be for a draft to be issued directly by the bank in favor of the probate registry. in that case, it relieves the applicants, the beneficiaries, or the burden of looking for money to pay for the estate duty. So that is part of the practice. Then once the payments are done and verified, the file is transferred to the department responsible for marking the will. The appointed executors are then required to attend to the registry for this exercise, during which they attest, they sign different documents, attestation documents, the asset declaration forms, and then all surety declaration forms. They are interviewed, and they are obliged. They must present sureties, minimum of 2 sureties, who will sign a bond that should any liability arises on the part of the executors, that they will take responsibility. So this will be verified by the court, and then if the court is satisfied, they will proceed to the next stage, which is the grant of probate. So upon approval by the probate registrar, who ensures that due processes have been followed, the grant of probate is prepared, reviewed, and sent to the office of the chief registrar of the High Court for final approval. And after the probate registrar's signature has been affixed to the grant of probate, the file is returned to the probate registry for sealing. The sealed grant is then delivered to the applicant or their duly authorized representatives. So that is a summary of the processes. Like we said, we have professionals that can undertake this, carry out this assignment or job on behalf of the applicant, because for most applicants, this can be cumbersome. That is a nutshell description of the processes for authentication of the will after the death of the deceased person. Thank you.
Thank you very much, Joseph. Thank you for articulating the process for validating a will. We'll now go back to our guest speaker, Michael Abiodun Thomas. Michael, please take us through common challenges in estate administration and strategies to overcome them. Thank you.
All right, thank you, Bukola. Oftentimes people will ask that, what are the challenges? And I'm sure also the questions are buzzing in, about difficulties that some people have experienced from time to time. I think the first thing we've identified generally is your choice of executor. As mentioned earlier, you could typically find that people use family members. Sometimes people use a trusted hand. And oftentimes those family members also double as beneficiaries, which has its own conflict of interest in the process which is being carried out generally. And we see a lot of things being fragmented. Sometimes family conflicts arise from this, and someone suspects that, this person is delaying this process is because he's not handling it very well. So those are some of the major challenges we've seen. At the end of the day, they end up appointing a lawyer, trustees, and in fact, more than half of the referrals we get are coming from estates where you actually had an executor who was named as a family member or a trusted person. And oftentimes, some of these trusted friends and acquaintances are not abreast of the rigorous process that a process will take, because you're required to have some capacity, some understanding of the legal process, the financial implication, the tax burden in it or so. And some of them just walk away without doing anything, even though they had the responsibility and they were named as that. And so this is the first challenge that we've identified. And so what do we recommend? We ask that please pick a professional. Talk to someone who has done it again and again, who have a team of financial experts, legal experts, experience and other things, and who can commit their time to it. That will save that challenge. The second thing we've also seen over years of experience is the lack of funds prior to obtaining a grant. So we encourage people now, and we make it perhaps a mandatory thing when you are drafting a will or you're putting out some estate plan, that there should be some funds that are set aside so that back and forth administrative cost is being borne. We've seen a lot of probate that are being stalled currently now because someone feels that, who is going to bear this cost? We run a business, we're not going to bear that cost. The lawyer is also not going to do it on his own pro bono. And so a lot of things are stalled. The beneficiaries don't want to put money together. The testator or the settlor, depending on whether it's a will or a trust, should set aside a fund. And when you do proper planning ahead of time, we can invite you to do some of these things. Another challenge we've seen is the legal implication. Again, a lack of uniformity. Joseph talked about the different applicable laws. And we also tell people that, look, for HNIs that have assets scattered around different jurisdictions, and even for some in the diaspora, there are issues of lack of uniformities of law, or perhaps even guidelines that are being released without taking cognizance of estate administration law that are already in place. I'll give you an example. Recently, the CBN released a guideline that stated that next of kin can claim any unclaimed funds or assets, right, that has been lying fallow for 10 years. And this is clearly contrary to the estate administrative laws and rules that have been put in place, that states that it recognizes that only a named beneficiary can have access to the assets of a deceased has been specified. You know, some of these things in the days ahead of us will lead to a lot of, litigations and disputes and back and forth. And some of those challenges are staring us in the face. Another thing is the delay in process, particularly in obtaining a letter of administration. Experience have shown that some of this process can take an incredible long amount of time, not only because of our system or our judiciary system, but because of certain administrative bottleneck that has been created. And lastly, but not the least, is family conflicts. Sometimes in light of this family conflict here and there, we encourage people that the effort you put to creating a tidy estate plan is worth the while, both in the now and even when that person is no longer in that scene again. These are some of the challenges and recommendations that we think is facing the probate process. Thank you.
Thank you. Wow. So you've also exposed us to how to manage our wills and how to manage all these things in terms of probate management. And I think you're right in the sense that I have a friend who has mentioned severally that every day she remembers her mom and the will her mom brought. She prays for her mom because even in identifying properties for the children, the mom went as far as saying flat 1 belongs to this child, flat 2 belongs to this child. You know, she was that detailed. So I totally agree and I understand what you're saying, and I hope our audiences are also enjoying and absorbing as much as they can. JJ, if I'm going to help us with common misconceptions about probate, and please just run us for about 5 minutes. We're running quite some time. Thank you.
All right. Thank you very much, BJC. One of the misconceptions about probate that people have is that when they sign a will, when they write their will, they have signed their death warrants. This is not true because just like we pointed out earlier, there's a time to be born, there's a time to die. And whether you have a will or not does not really have effects on when this can happen. But we know that the fears are not totally unfounded. People sometimes are afraid that, when their beneficiaries, their wife, children, or other persons are aware that they are beneficiaries of the will, they can plan terminated premature deaths, one way or the other. So we're saying that that's not necessarily true. You are not obliged, one is not obliged to disclose the content of a will when prepared. It can be kept confidential and known only to the executor and solicitor when the time comes. Another misconception is that, people feel that, once they write a will, it will not give them opportunity to mend it. If supposing they change their mind or something happens later on, what will happen to the will that they have already signed? You might want to. So we say that, look, a will is just like an agreement. An agreement, once signed, sealed, and delivered, can also be amended through what we call addendum to a contract. So similarly, a will can be amended through what we call codicil. An amendment to a will is called a codicil. You can have a first amendment called the first codicil. You can have a second amendment called second codicil. You can have a third amendment called third codicil. As the need arises, assuming you acquire new assets, assuming there are developments, you want to change your mind over a bequest you have already made in the past, you can always do that. Another misconception is that people assume that once they have a disclosure of their next of kin in certain transactions, that will be suffice in lieu of a will. That is not true. The laws have cases, numerous cases in the courts, it has been shown that next of kin is not recognized. It's not an automatic recognition of the person as a beneficiary to the estate of a deceased person. At best, a next of kin is somebody who whose name have been provided, is obliged to provide information about the deceased person. In other words, it could be a wife, it could be a brother, it could be a sister. So that person can, in the worst case, best case situation, apply for the probate, but not that it gives him automatic. In most cases, somebody at the point of employment, you are obliged to state your next of kin. At the point of opening a bank account, at the point of boarding an aeroplane, at the point of going to certain transactions, even your pension funds account opening, your next of kin does not equate to being automatic beneficiaries of the estate. So that's a misconception. We also have the issue about people feel that, they don't have enough assets to pass on. So for that reason, they don't bother to have a will. That is not good enough. Because everybody has something. If you don't make any plan at all about it, total strangers may come and inherit that person's asset. Unauthorized persons can, at the end of the day, have access, lay claim to the estate and have access to it. And also, some people feel that they are too young to have a will. That is wrong. Where you have joint properties, joint tenancies, at the point of marriage, at the point one is out of school, getting into employment, usually we have people named as a next of kin. You don't have a will. So at the point of getting married, some people get married and unfortunately they die young. It's at that point you find out that even though they have a wife and young children, the name of their next of kin is their parents, either their mother or brother or younger brother or younger sister, something like that. And so this often leads to problems. So we also have people assuming that their partners, their relations will automatically inherit the estate when they pass on. This is not true, as we have shown, that when a person passes on without having a will, the person is just leaving his assets open for third parties to lay claim to it, and there can be acrimony, as we have illustrated in the past. And we are saying that there's an office of the Administrator General of the states. Lagos State, for example, Ogun State, they have it in all the states of the Federation. The express purpose of this statutory office is to take over the estate of persons who that is fallow, that nobody has come to claim them, or there is contention about it, and you have not. For those of you who are older, not far from along Ikorodu Road in Lagos here, there used to be a hotel called Hotel Bobby, belonging to the late Bobby Benson, a musician who was very well known in the 60s and the early 70s. Unfortunately, when he passed on, it will appear there were family squabbles here and there, and they were never able to settle it. And that hotel became, abandoned and became a place where criminals and all sorts of shady characters were hiding. The state government had to take it over through the office of the Administrator General. So that's an instance of where an asset that is not subject to probate can become automatically inherited by the government. And that is the end of it. If you pass through that corridor road, you will never know, because that hotel has been demolished and leveled, and that land is put to some other uses by the government. So those are some of the misconceptions about probate that people need to know and know how to navigate around it. Thank you.
Wow. Thank you so much, Joseph. Wow. That's some information and exposure right there. So the fact that we even penciled our next of kin at every point that we get to does not determine who will have access to properties or assets when one finally, goes beyond. So, I mean, the one thing that one has taken out from this is that it's compulsory that we set up a will, no matter what we have acquired or what we think. I think it's just a way of tidying up things. The same way you plan for school fees for the children, the same way we plan for our 5-year strategy outprint or blueprint, both on our personal lives or our corporate world and all that. I think it's something we should all start thinking of. This is real explosive information for us. And then finally, Michael, I'm taking you on the last strand of question on this panel. Can you please help us with the importance of estate planning in protecting future inheritance? Thank you.
All right, thank you so much, Bukola. And so we quickly want to say that I think for, again, most of our listeners here, I think so far you've been very intentional about your life. You've been intentional about your assets. You're intentional also about growing your assets. You should also be intentional about putting together a plan that ensures that your assets are transferred to your beneficiary as you intend it. Estate planning helps you ensure that your assets are distributed as intended, and it is not subject to a state-dictated administrator who would do something contrary to what you want. It's just taking charge of your affairs in a very intentional manner. An estate plan helps you not only to put a holistic view over your assets, whether they are intellectual properties, whether they are your RSC account or your bank statement, a total sum of it. And two, to also be able to clearly state out who your beneficiaries are. Estate plan is also very important in minimizing family dispute. We've seen families within our jurisdictions that the dirty linings of the family have been washed in public courts and so every other things. It guarantees you a lot of privacy, enables you that your affairs are private. A will remains private until it is read in a court and it is deemed as marked, and then it can become a public document. It gives a lot of confidentiality in terms of how this has been done. And under an estate plan, if you're utilizing the services of a trust, it protects your asset from creditors. Again, we tell people that having a will is just basic, it's fundamental. There are many other estate planning tools that are more efficient and effective. You can have a trust over your asset, you can have a living trust, you can have a medical power of attorney, you can have a financial power of attorney. Who makes decision? Those are plans that things happen in life, but when you put those plans in things, it gives you a lot of peace of mind. Statistics have shown that those who have estate plan tend to live longer and healthier lives because they have their house completely put together. Estate plan is also important in terms that it reduces your tax. When you explore the possibility of having a trust in some of the things you do, whether your trust is an intervivos trust or it is an offshoot of your will or so, it helps you to navigate and use tools like giftings or transfer of trust. And those are things that we are happy to clearly explore with you as time goes on. We also indicate that one of the importance is that it enables you to plan for incapacity. We hope for the best, but we also plan for the worst in life. To say that, look, if something happens, what do I fall on? Who can take a decision for me if I can't take a decision, either by some sudden incapacitation? Some of those things help to preserve. Oftentimes, people think of creating a will, maybe rightly as Joseph mentioned, only when they are old. But in reality, when you have minors, those are the times you should put an estate plan in place. If you're going to take an insurance, if you work for an organization and there's a group life insurance over you, you should also be able to put something in place for your beneficiaries and protect your loved ones, so that the concept of transgenerational wealth that would happen in the next 10 to 20 years, you can have a clear demise. There are certain families all over the world who have existed for over 200 years and even more. who have been able to preserve family wealth through effective estate planning that allows for transgenerational wealth. Minors are also being protected, where someone who has a wife much later in his life and has minor children and has adult children, estate plans enables you to be able to plan not just for the adult, but also to protect and have ready plans for the minor who bear your name or who are linked to you. And your beneficiary is not just your child, there could be your ward, there could be a dependent, there could be anybody whom you have in place. And those are some of the importance of being able to have an estate plan as a means of preserving your inheritance and as a means of transgenerational wealth for the ones that you truly love. You work this hard, plan very hard to ensure that all of these things are put in place. Thank you so much.
Thank you so much. Thank you so much. Thank you so much, Michael. You've really exposed quite a lot. And I see the questions, buzzing, asking several, the audience asking several questions. I'm excited to be communicating all this and ensuring that we empower people with knowledge. I'm really, really excited. And before we go to the question and answer session, we would like Muritala, who is the regional head of Port Harcourt branch, Africa Prudential, to give us speed for speeding up the probate process, knowing that most times one of the ways by which people gain wealth is through investments in capital markets, security, and so many others. And so Africa Prudential, who happens to be the registrar to quite a number of blue chip companies, we usually have shareholders and investors, executors, administrators come into our offices to find out how they can go about all this. And then we would have Muritala take us through the tips for speeding up this probate process. First, Muritala, the floor is yours. Thank you.
Yeah, thank you very much, BJC, and thank you to the speakers, Michael and JJ. They've actually touched all areas of these processes. For probate itself, and for you to do that, it's complex, but however, basically what you need to make available is the death certificate of the deceased. Once that is available, you're good to go. There shouldn't be any rancor within the family. There should be a letter of authority, whosoever that is going to act. Now, once we get this, we'll help you to do all necessary filing. If you have not done any documentation, or if there is documentation in place, make them available and proceed to act accordingly. So once we have that, we are good to go.
Okay, thank you very much. Thank you very much, Muritala. So it's obvious that we have answers to questions that everybody has asked. Once you have a requirement as stated, we can help you either through the trustees represented by Michael, or even through ourselves going through with all the documents you require. The most important thing is that you get solutions to all questions and all requirements that you've been seeking. And then not the least, we go to Temi Tokwe, who currently is the head of operations. Temi Tokwe, can you help us with navigating the probate process through African Prudential PLC? Just give us a brief overview of how to navigate the probate process.
Thank you, BJC. Hello, everyone. Our speakers have provided valuable insight today, covering all aspects of probate services and will validation. At APPLC, we aim to take the stress off your shoulder. We will do this for you. If you're interested in our probate services, please feel free to contact us at commercials@africaprudential.com. Our services includes will validation, letter of administration, share transmission, outstanding dividend, money in the bank, legal guardians, and document preparation. All this will guide you to get a seamless experience. Thank you.
Thank you. And then we've come to the most crucial part of this webinar. Now we're coming to answers, questions. We've seen so many questions. What I'm going to do is I'm going to try to compress questions that are similar so that we can have them answered at once. And then I will just appoint one of our guest speakers or even our speaker to answer the question. So the first question that is here is, as the next of kin, How can one access, okay, questions are dropping in. Okay, a minute, please. As the next of kin, how can one handle the process of collating all the required documents for the probate process? That's one. I'm going to try and put about 2-3 questions together. What is, how does one handle the case of a corporate account, especially a limited liability company or a sole proprietor, where there's a will and where there's no will? Let me add one more question, then I'll ask Michael to answer that question for us. How do you go about shares of a deceased person from companies that have either merged or metamorphosed into new companies? I've taken 3 in 1, all almost similar. Michael, can you help us with those questions?
Okay, thank you. I think the highlight of the questions that are being asked is how do you go through this process, both for someone who died intestate and where there's a will. Again, one of the benefits of estate planning is business succession plan. Those are all tools that you can use. Ownership is different from management. One of the things you own, right, is the ownership of the company. I take, for instance, shares, which some of the times they are listed and all the rest. Who do those shares go to? Who are your beneficiaries? There are people who have set up, family trust that ensures that the shares of the company remains within the family. None of the family member can sell, or they're transferred directly either through a gifting system or a system that passes it to them through a will and say, look, you take over these shares and XYZ. But where a person has died intestate, that means that this falls into part of the inventory that will be covered through. And you go to CSCS. Again, that is why we say going through a letter of administration is a very cumbersome process. Now you're having to trace a company that has been merged, and that can be verified when you talk to people like Africa Prudential, or you go to the CSCS to certify and say, look, we have shares here, we need you to help us trace. How do we find out there? There are a lot of unclaimed dividends right now. If you go to SEC website, you currently see a place where you can file in, you can enter in the number as at when it was before, or they could show you how you could trace in the new numbers. All of these processes are what your solicitors or your trustees or your registrars can do for you over a period of time. Please do not hesitate to talk to a professional, because they are time consuming. There are people who have done it again and again, and it's faster with them. Thank you.
Thank you very much, Michael. Joseph, I'm bringing a couple questions to you as well. Okay, so someone says, hold on, questions are, okay. In a situation where all executors to a will are dead, and after the will was read at the probate, no tax was paid, and letter of probate not obtained, what can the beneficiaries do? That's question 1. Someone also says, I have instructed my dividends to be paid into a joint account. At death, will this instruction become invalid? And one more question I'd like to add, how do I apply for a letter of administration for a sale of an deceased person who didn't write a will? Joseph, can you help us with that question, with those questions?
Okay, if I get the questions well, in the case of a person who had instructed for a joint account, for his dividend to be paid to a joint account while he was alive, the question is whether his instructions will be obeyed after his passing.
Or whether it will be valid after his passing.
Yes, it will still be valid because it was given while he was alive. So that was his standing instructions, except if that statement has a caveat, that provides for review at a subsequent date. But if it was the express instruction that the dividend should be paid there, it should be honored. That. So, but that is not upon his death too. That even while he was alive, that the dividend should be paid there. But if it's intended to be paid for the purpose that when he dies and all of that, that looks more like attempting to create a will or something like that. So in that case, the proper thing is for him to formalize it. It has intention that whether he's alive or whether he's dead, the shares, the dividend should be payable to the joint account or any other account. The proper thing is to have it in form of a will. And then somebody asks a question about in the case of a corporate account, assessing a corporate account of a disease, a person, so what happens that a company is a separate, has a legal personality of its own. So if any of the directors or shareholders are dead, the proper thing is for interested persons to, get the death certificates and show their interest in the company and apply to CAC, Corporate Affairs Commission, to change the directors of the company. And when you are done with the CAC, you can now approach the registrar with the CAC document showing that there have been changes in directorship or changes in the shareholding. Once the CAC is certified and the registrar can confirm that the applicant has gone through, that is the valid document from CAC, the registrar will deal regardless. So that's another way dealing with it. So I also see the question about the merge successors to the estate of a person who has shares in it, has gone through mergers and all of that, subsequent changes. So of course, when there's a merger or subsequent changes, there's a successor in title. There's a company that succeeds to the entity that have been that's no longer in existence. For example, we're aware that during the banking consolidation, a number of banks merged or were acquired. Fidelity, FSB International Bank was acquired by Fidelity Bank. Some other banks acquired, FCMB acquired some other banks. So they take responsibility or liability, assume the liability for the shares of the defunct company, the company that they took over from. So that is fairly simple. Go to the registrar of the surviving company to claim the dividend or for transmission of the shares as the case may be, assuming all documents have been submitted to the satisfaction of the registrars. Thank you.
Thank you. So before you go, another 3 questions, and I'll come back to you. Can an executor named in the letter of admin appoint another to act on his behalf, like a power of attorney? That's 1. 2, how can you transfer the shares of a deceased person who has no will? And then, what happens when a testator's will has not been read, but it contains the burial directives by the testator? Should the burial instructions be in a different document?
Okay, I'll start with the last one. Burial instruction is better to be in a separate document, but it can also be in a will, because we are talking about the now. When you're talking about burial instruction, we're talking about the now, okay? But don't forget where we started from, where we said that before you can apply for probate, it depends on where you are. Abuja, you can apply after 7 days of the death of the deceased person. If you're in Lagos, you must observe 14 days. So if you're not in a hurry, within 14 days thereafter, you can apply. But if it's in a separate document, it makes it easier for the family to proceed to carry on the burial instead of waiting for 14 days there. But if it's contained in the will, there's nothing one can do but observe, because it's such that you must observe a 14 days lag before an application can be brought. How to assess the estate of a person who died intestate, without will is simple now. You apply for letter of administration, as already explained by Thomas and myself during our presentation. So it takes time, just like he said, it varies from state to state, because there's also a period, there's a challenge for people getting the documents required. For example, getting the NPC, National Population Commission certificate to show that the person is dead. Some people will just come with the death certificate, but they don't get that. So you tell them, go and get it. Every day of delay adds to the prolongation of the application process. Even when all the application documents are submitted to the probate registrar, it has to be published in a gazette of the state or a newspaper in the locality where the disease was domiciled. And you must observe a period of 21 days for possible objection for members of the public or interested persons. And all this adds to the time. So experience has shown that you may get a letter for decision within 6 months to 1 year. Sometimes it can take 2 years. But when it's very fast, it can take you between 3 to 6 months. But in the northern part of Nigeria, I think it's much faster. You can get it within 1 to 3 months. For any state in the north, their processes are much simpler. But down here, down the south here, especially in Lagos, you can't get it for less than a 6 month period. I don't know if I got the questions well. So that's what I can recall from the questions. Thank you.
Bukola, I think you're muted. You're muted.
Oh, thank you so much, Joseph. Okay, so now I come straight to Mr. Michael. Someone has said most of the wills written in diaspora states that wills can be accessed anywhere in any part of the world, but practically this isn't true. Can you explain? And also, there's a question that was particularly directed to Mr. Michael. Please, can you take us through the process and the cost of a private trust? Do you have anything like that? And how is it managed? And finally, how do you include or formalize your inherited estates or shares to your own will or properties legally? Did you get the 3 questions? Thank you.
All right, thank you. I think for the first one, in terms of a will being applicable anywhere or any place around the world, I think that's a very difficult thing. Conflict of laws will not allow for that. There are different laws and jurisdictions that govern different jurisdictions from around the world. The legal system in the United States is different from the UK system, and for some of our clients who we offshore asset for in different part of the diaspora, the intricacies are as broad and as wide as those countries apart from themselves. Again, there's a system around it under an estate plan where you can hold this either through a holding company, which is largely based on what your objectives are. Are you trying to save yourself from tax? Are you considering your beneficiaries? There are a lot of companies, SPVs, and trusts that are being set up in Mauritius, British Virgin Islands, tax haven jurisdictions around that. Again, no 2 case is the same. We need to look at the applicability of those things. However, we are talking about a will here, and the laws of that jurisdiction governs the applications and the process of that will. And so I do not know that it would be able to apply to other things. And I think the primary concern around it is actually a will applying to assets in other jurisdictions. Now, don't forget that for you to enforce that, which is a process that can be done, you will have to abide by the law of where those assets are resided. And I'll give you an instance. If I have properties in London and I mention in my will here, and that this property should go to my second son, and everything that is attached and affixed to the property itself. Now, for that to carry out effect, right, we would need to pass it through the legal system of the English law and to be able to apply it and ask for enforcement. So those processes are not simple walkover processes. We will ask that at the point where that will is being created, you can actually create structures around it, a gifting structures under the trust, or to create some sort of trust that is transferable, or an SPV where shares are being transferred, holding those assets generally. I think the other question that speaks to shares, I think, about what kind of trust can one do and what is the process. So typically a trust allows for a settlor, the person who's setting up the trust, a trustees who act as your third neutral party, holding on your asset in trust, and of course the beneficiary. And under a trust, we say that the settlor is the first beneficiary and every other person named under it. The good thing is that whilst a will is ambulatory, that means it takes effect only upon the death of the testator. A trust takes effect immediately, so you can actually watch your estate being managed whilst you are alive and being directed. I would like to tell people, September, April, January of every year, we are paying hundreds of school fees around the world because of people who have trust in place. So they've literally taken themselves out of it. And these are ranging from people with what they have regular assets, just an RSA account, one bank statement here, a few shares here, to high net worth individuals who have chains of businesses and who will not be bothered about this integrity. So every bill that comes from their dependents, whether they are their direct children or their ward, and bills like school fees, medical bills, all of that is being paid from the trust because there is a system of accountability, transparency, and the fiducial obligations on the trustees ensure that you do not commingle your client's fund with the books of your account. That system allows you to run that process because we have different kind of trusts. You could have a living trust. You could also have a blind trust for politically exposed persons. You could have a settlor directed trust. The peculiarity of your case based on what you want to achieve, your dependents, and where you are at the stage of your life, will be able to do a quick analysis and recommend to you. Our fees are very affordable. They are, very discardable compared to the benefits, the peace of mind, the ease and seamlessness which you enjoy. I'm not sure I can remember the third question, but I hope I did address the first two.
Okay, yes, you did. Let me try and get the third question back. Okay. There's a question on the dead executors who have not paid tax nor obtained probate letter. What would the beneficiaries do where the dead has not obtained tax or paid for probate? I don't know if you understand that question.
Okay. Do you want to take that, Joseph, or should I go on?
Please go on.
Okay, so this happens a whole lot, and I get it. And I'll give you an instance right now. A testator appoints a close friend as his executor. That executor passes on maybe a year before the testator passes on. We've seen instances like that. Why? Because they were friends, very trusted contemporaries, and the testator did not have the time to amend through a codicil the will, or didn't just remember so. And so by the time the will is being brought to the forefront, let's search for a will, and we do a searching, and you realize that the executor who is supposed to initiate and carry out this process is no more. Or even within the course of that probate process, the executor passes on, or they are not even interested. In fact, some of them have found how cumbersome it is and they just don't show up anymore, right? Because oftentimes the people you appoint as close acquaintances and friends and families, they are not being paid. And so when they have to go this back and forth, they don't earn anything from it. After a while, they get tired and they are just disinterested. The estate suffers and the beneficiaries do not derive anything. Now, what can be done at that point in time? An application can be brought by the beneficiary before the court of law, asking for substitution or replacement or appointment of an administrator in place of the executor that has passed on. Again, we tell people, a company is in perpetuity. If I'm not here tomorrow, somebody else will carry it on. Appoint a corporate trustees or perhaps a registrar like this to be your executor so that it is easy for you to have perpetuity instead of tying it to just one person. The entire thing, again, you can have is to have co-executor. That means maybe one of your child or a beneficiary is co-executor with a trustees. All of those things allow for a handshake so that the process are not stalled. Now, when you apply for that application and the court grants one, whatever has not been done can now be completed. If an inventory of the asset has not yet been done and tax has not yet been computed, now it can be done. When a new person being appointed, he can pick it up from where it stopped. Those tax can be paid, because tax after God is tax, so you're not going to escape tax at all. As long as a will has come before the probate court, tax will be paid. Whether you pay it now or you pay it later, the tax will be paid. So you go through that process again. Thank you.
Thank you very much. Thank you so much. Well, I still see some questions, but we have run out of time, and would make it our possibility to respond to. Thank you all once again for joining us today. We hope you found this session insightful and valuable. I believe so. Type of questions that came out. A special thanks to our co-guest speakers, Mr. Joseph Jibunoh and Mr. Michael Abiodun Thomas, for sharing their expertise and providing us an engaging presentation. As we have learned today, the probate process can be made smoother with the right information and professional guidance. Emphasis on professional guidance. A lot of times our guest speakers made references to say, because they are skilled people and they've done it and done it again, it would be nice to ensure that you stick the expertise of a professional person. Africa Prudential will be here to support you through every step of the way, even if you have to be referred to the trustees, who is also United Capital Trustees. We'll be here to support you. Just reach out to us on any probate or estate planning needs that you may require. We hope today's session gives you a better understanding of how to unlock inherited wealth and navigate the process of probate effectively. If you have further questions, please do not hesitate to contact us after this event. But before we close, just a few reminders. The recording of today's webinar, along with any resources or materials, will be sent to you via email shortly. We would love to hear your feedback as well. Please do send information on how we can improve better, or what other areas you would like us to have or host webinar sessions on. And if you have any further questions, please send to the email that has been posted on this webinar session, the commercial@africaprudentialplc.com, and feel free to reach out to us directly or connect to us through any of our social media platforms. Once again, I want to say thank you to our guest speakers and also our speakers from Africa Prudential, and I say a big thank you to me for moderating the session very well. Thank you so much, and do have a very great day. Bye.
Thank you, Bukola. Thank you, everyone.